Good morning, everyone. Hello. I'll shout. We're going to get started. So good morning, and thank you very much for coming today to join us on our Employment Extravaganza. We kick off with a whistleblowing whistle-stop tour. And the classic aim, of course, of when the Public Interest Disclosure Act was introduced was relatively straightforward. An employee raised concerns about wrongdoing in the workplace. The employer reacted horribly, disciplined them, sidelined them, dismissed them, and the tribunal's task was to decide whether the employee had made a protected disclosure, and if so, whether that disclosure caused the detriment or dismissal complained of. Now, of course, those cases still exist, and they continue to occupy a good deal of tribunal time. But they're not really the cases that now reach the appellate courts or that are most likely to occupy the minds of us employment lawyers and prove the most vexing. The most difficult whistleblowing cases are now much more likely to involve four recurring issues. So firstly, attribution. Who knew what, when, and whose state of mind counts. Second, tainted decision-making. So how far can an ostensibly innocent decision-maker be fixed with the motives of others? Third, complex causation cases where there may be mixed motives or mixed causation issues, so material influence as against the reason or principal reason for dismissal. And the fourth issue, as Wicked Vision illustrates, is the architecture of the statutory scheme itself, specifically the boundary between detriment and dismissal and the reach of individual liability. So the paradigm has shifted. We've moved more from the straightforward model of employee speaks up, employer reacts badly, tribunal decides why, to cases in which the real difficulty lies in identifying the legally relevant actor, the legally relevant motivation, and the legally relevant statutory route. And those are the issues that Joseph and I are going to focus on in this morning's whistle-stop tour. Joseph's going to begin by looking at three recent authorities. First, difficult tainted information scenarios post-Jutty. He'll then move on to look at the Rogerson case and the definition of detriment. And finally, he will explain how we got to the Court of Appeal's decision in Wicked Vision. I'm going to then pick up the arguments that are now being considered by the Supreme Court to see where we may be heading on the whole detriment and dismissal question. And I'll then end by looking more broadly at where further developments in whistleblowing law may emerge. So over to Joe.
Thank you, Carol. Good morning, everyone. Henderson was a typically knotty tainted information case, so I'll start off here while the morning caffeine is still coursing through our veins. But first, a cautionary note. There was no challenge to the correctness of Ossipoff in Henderson. And since Ossipoff is now up in the air, as we'll come on to, Henderson has to be treated with a degree of caution. But unless and until Ossipoff is overruled, Henderson does remain a useful authority. Now, the claimant had brought Section 103A automatic unfair dismissal claims. She brought that against her employer. She also claimed against two individual respondents, her line manager and the dismissing manager, both for the detriment of dismissal, for which she also claimed the employer was vicariously liable under the detriment provisions. The claimant had been the subject of a conduct investigation. There was a disciplinary hearing which was due to be chaired by her line manager. The line manager knew that the claimant had previously made the disclosures which she was now claiming were the protected disclosures. However, the disciplinary hearing was rescheduled, which led to a change in the hearing manager. And this second manager was not aware of the history of the claimant's disclosures, having only recently joined the business. And the eventual decision to dismiss was taken by this second manager. The reason she gave for dismissing the claimant was what the tribunal had found to be a genuinely held belief that the claimant had committed misconduct. The reality was, though, that the claimant's line manager, the first manager mentioned, the first personal respondent, had been having a key influence on the dismissing manager's decision by various means during the process, and was later found by the tribunal himself to have been heavily motivated by the protected disclosures. Now, the automatic unfair dismissal claim failed because the evidence didn't satisfy the reason or principal reason test of causation, but the interesting aspect of the decision is on the detriment claim. It's important to note, as I foreshadowed a moment ago, that the claimant had in her pleading nailed her colours to the mast of dismissal. No detriment short of dismissal was pleaded. So, to the tribunal's findings, in respect of the line manager, he could not be liable for the detriment because he had not made the decision to dismiss. In respect of the dismissing manager, the tribunal found that she was liable even though she had not herself been motivated by the protected disclosures. And in respect of the employer, it was therefore liable vicariously for the dismissing officer's tainted decision to dismiss. Those findings of the tribunal led to two linked questions on the appeal to the EAT. Firstly, can JUTI apply to detriment claims against individuals as well as to automatic unfair dismissal claims? And secondly, can an otherwise innocent decision maker be liable under the detriment provisions when acting on tainted information? And the solution ventured by the EAT was to adopt the approach that had been taken in the discrimination case of Reynolds and Silphis, which is to say that it would be unjust to hold an innocent decision maker liable because of the unlawful motivation of another employee. And the EAT decided that JUTI did not require a change in approach. And that seems to make sense because fundamentally JUTI was about how to identify the state of mind of an inanimate, a corporate employer for unfair dismissal purposes. It was not a detriment case, and there could be no personal liability for an unfair dismissal. So on the facts, the dismissing manager, so held the EAT, could not be liable, and nor could the employer be vicariously liable. Finally, just before we move on, I hope with working slides, to the next case, as I foreshadowed a moment ago, there is a valuable lesson for claimants in how they plead detriment claims. The claimant here had only pleaded the detriment of dismissal, nothing short of it, nothing prior to it. Carol will come back to pleadings later. But the warning issued by the EAT in this case was that if the pleading says that the detriment is dismissal, that is not the same as saying that the detriment might have caused or contributed to the dismissal. And that was the reason why the line manager couldn't be held liable in this case. So if the claimant wishes to rely on pre-dismissal conduct, the pleading should make that clear. We're moving on to the Rogerson case. So we had the decision of the Court of Appeal in Rogerson in December, and that was a case which illustrates the wide reach of the whistleblowing provisions, encompassing questions of post-employment detriment, cross-border issues, and judicial proceedings immunity. So the facts in a nutshell. Mr. Rogerson was employed by a Singapore-registered charity, but he performed some of his work in the London residence of an individual who later became a respondent to his employment tribunal claim. After his employment ended, Mr. Rogerson made what he said were the protected disclosures, and these were about the alleged conduct of the individual respondent. He then further alleged that the charity, his employer, subjected him to detriments on the grounds of those protected disclosures. We can put aside for the moment the claim against the individual because that was separately dismissed as out of time, but the balance of the case proceeded as against the employer. Crucially, among the alleged detriments was the respondent charity's commencement of arbitration proceedings against Mr. Rogerson in Singapore for an alleged breach of a confidentiality agreement, and the arbitration claim referred to matters which were precisely the alleged instances of whistleblowing. In the Court of Appeal, there were three issues. First, could the commencement of the arbitration constitute a detriment? Second, was there any policy reason why such a detriment should not be actionable? And third, did judicial proceedings immunity cover the commencement of the Singapore arbitration? Now, with a very firm focus on the protective purpose of the whistleblowing regime and on the principle that a wrong should have a remedy, the Court of Appeal came down in favour of the employee. You will see on the slides in your pack that I have quoted the judgment of Lady Justice Andrews on the first issue. The court decided that the commencement of the arbitral proceedings fell squarely within the meaning of an act causing a detriment. To quote Lady Justice Andrews, apart from dismissal, it is difficult to conceive of an act which is more likely to subject a whistleblower to a detriment than the commencement of legal or arbitral proceedings against him or her, which are designed to obtain financial recompense for previous protected disclosures and or to prevent future protected disclosures. So, fell squarely within the definition of a detriment. On the second issue, adopting the purposive approach again, the court held that there was no policy reason why the detriment of commencing arbitral proceedings should be immune from suit. Quite the contrary. Section 43J, on the slide there, will perhaps be most familiar to us as the source of the standard provision in settlement agreements carving out protected disclosures from confidentiality clauses. But here it was applied and held to be wide enough to cover such a clause, quote, to the extent that it could be used to preclude a worker from making a protected disclosure or to give the employer a remedy in damages in the event of a protected disclosure being made, unquote. And moreover, the Court of Appeal decided that Section 43J would render unenforceable any Singapore arbitral award which treated the clause, the confidentiality clause, as effective to preclude Mr. Rogerson from making a protected disclosure. Thirdly and finally, on the somewhat technical question of judicial proceedings immunity, the judgment is, I suggest, essential reading if the issue arises in any of your cases, but the broader point of interest for present purposes is that the act of commencing arbitral proceedings aimed at stifling protected disclosures was not covered by the immunity, perhaps unsurprisingly. The distinction drawn by the Court of Appeal is between the act of commencing proceedings, which is not covered by a JPI, and statements made in the course of such proceedings, which may well be covered, but that issue didn't arise on the facts of this case. But the highlight of the whistleblowing year was certainly the Court of Appeal's decision in Wicked Vision. Wicked Vision being heard with a conjoined appeal in Treadwell and Barton Turns developments. And this has, of course, thrown Timmis and Ossipoff into doubt. Those two conjoined cases have now been heard by the Supreme Court, with indeed our very own head of chambers, Adam Solomon KC, leading the arguments for the employees there. In both of the conjoined cases, the claimants had brought claims of automatic unfair dismissal and later applied to amend their claims to include a detriment claim based on the act of dismissal, relating to the act of a co-worker for which the employer was vicariously liable. Now, I've extracted on the slide the relevant subsections of 47B as an aide-memoire. The two separate employment tribunals gave opposing decisions on the amendment applications, which relied on the legal question of whether or not such a detriment claim could be brought. Then, on appeal to the EAT, different constitutions of the EAT allowed appeals against both decisions, leaving conflicting authority at EAT level. So, to the Court of Appeal. The issue turned on whether the tribunals had been bound by Timmis and Ossipoff, and the Court of Appeal found that they had been. And on top of that, the Court of Appeal decided that it too was bound by the doctrine of precedent to follow Ossipoff. Now, just before drawing out the key aspects of the judgment in the Court of Appeal, a brief recap of Ossipoff. In that case, the Court of Appeal, Lord Justice Underhill giving the leading judgment, decided essentially two matters. First, that an employee can claim under the detriment provisions against a co-worker for the detriment of dismissal and bring a vicarious liability claim for that act against the employer. Lord Justice Underhill said that all that section 47b(2) on the slide there, all that excludes is a claim against the employer in respect of its own act of dismissal. And the second point decided in Osipov was that section 47b(2) does not prevent the recovery of loss flowing from the dismissal if it is caused by the unlawful detrimental treatment of a co-worker. So returning to Wicked Vision, three key aspects of the decision, I suggest. First, the court decided and focused on the wording of the section 47b(2) exclusion as referring to a detriment, quote, amounting to dismissal within the meaning of Part 10. And that is a matter of substance, not of form. The question is the claimant complaining in substance about the dismissal or about something prior to dismissal? The second theme that emerges is that the exclusion, the section 47b(2) exclusion, applies to the whole of section 47b. And the effect of that is to mean that it prevents an employee from claiming dismissal detriment against the employer directly under 47b(1), and, contrary to Osipov, against the co-worker with the employer vicariously liable. And the third point to make about Wicked Vision is that there are reasons to think that Osipov was decided on unusual facts, because, of course, in Osipov, the only route to any recovery was against the co-workers because the employer was insolvent. The Court of Appeal in Wicked Vision was keen to stress that, in its view, Osipov went against the grain of earlier Court of Appeal authority in Melia and Magna Canse, which had explained why the detriment and unfair dismissal provisions are separate regimes. One of the arguments in Wicked Vision was whether there had to be a concurrent claim against the co-worker for the dismissal detriment claim to bite. In Osipov, the individuals had been added as respondents to the tribunal claim. And whilst in Wicked Vision this was found to be a, quote, slightly different context, unquote, it didn't enable the court to depart from Wicked Vision under the doctrine of precedent by which it considered itself to be bound. So, with this frontal attack on the reasoning in Osipov, there are now conflicting authorities at the level of the Court of Appeal on this important question, which, as the Court of Appeal itself noted, could only be resolved by legislation or by the Supreme Court. On which tantalising note, I hand back over to Carol.
Thank you, Joe. The perfect example of how Littleton barristers keep going no matter what. The issue before the Supreme Court is deceptively easy to state. Does the Employment Rights Act give an employee one route or two routes to claim that their dismissal was caused by their protected disclosure? More specifically, where an employee says that they were dismissed because of whistleblowing is the only available route a claim for automatic unfair dismissal under Part 10 and Section 103A, or can the employee also, or alternatively, pursue a detriment claim under Part 10 and Section 47B, including against a co-worker personally and against the employer on the basis of vicarious liability? Now, the appellants in Wicked Vision, the employees, say very firmly there is one route. Their argument has the attraction of simplicity. They say the statutory language creates two separate and carefully divided regimes. On the employer's case, Part 5 deals with detriments short of dismissal, while Part 10 deals with dismissal, including whistleblowing dismissal under Section 103A. Now, on that reading, Section 47B2 performs the separating function. It disapplies Section 47B where the worker is an employee and the detriment amounts to dismissal within the meaning of Part 10. So, say the employers, there is only one route for an employee challenging dismissal for whistleblowing. And they reinforce that submission before the Supreme Court in three ways. First, they say that that same kind of disapplication formula appears across much of Part 5, which indicates, they say, a statutory intention to keep detriment and dismissal apart. Second, they pointed to different causation tests. So Section 103A requires a protected disclosure to be the reason or the principal reason for dismissal, and by contrast, Section 47B applies where whistleblowing is merely a material influence. And third, they stress the different remedies available. So Part 5, providing just and equitable compensation, potentially including injury to feelings, whereas Part 10 has its own remedial code, including reinstatement and interim relief. And on their case, if dismissal can be litigated under Section 47B, those carefully differentiated tests and remedies begin to collapse into each other. The respondents, the employees, say, well, that's just too blunt a reading of Section 47B2. They argue that the section or the subsection excludes claims related to dismissal only where two conditions are both satisfied. First, they say the act complained of must be the employer's own act of dismissal. In other words, a claim based on the employer's primary liability. Second, the dismissal must be within the meaning of Part 10, which on their case means a dismissal where the protected disclosure is the sole or principal reason. And if either condition is absent, say the respondent, Section 47B2 doesn't bite. So on their interpretation, if a co-worker engineers the dismissal, that is not the employer's own dismissal for the purposes of Section 47B2. And if the whistleblowing is only a material influence rather than principal reason, then the dismissal is not within the meaning of Part 10 either. So on that approach, Section 47B remains available. And the respondents say that the appellant's construction would deprive those 2013 amendments which introduced co-worker liability of much of their practical effect, because in the most serious of whistleblowing cases, co-worker liability would exist for things such as demotion, sidelining, but then disappear when the retaliation becomes dismissal. And in mixed motive cases, that would leave dismissed whistleblowers without a viable remedy beyond a Section 103A claim that they can't satisfy. So if you take a straightforward example, a senior manager engineers the dismissal of a whistleblower, the manager acts because protected disclosures have been made, and the manager manipulates the process to ensure that dismissal occurs. Why, asks the respondents, should the manager escape personal liability and the employer escape vicariously liability merely because the retaliation ultimately takes a form of dismissal rather than some lesser detriment? The respondents say that Parliament cannot sensibly have intended there to be such a gap. The whole purpose of the 2013 amendments was to extend protection, and the respondents say the legislation should be interpreted in a way that preserves practical effectiveness. Protect, who are intervening, broadly supports the respondents but get to it by a slightly different route. Their position is that Section 47B2 is textually ambiguous and should be read as a boundary provision that keeps the incidents of Part 5 and Part 10 distinct rather than as an absolute exclusion of Part 5 whenever dismissal is in play. On that approach, both routes may sometimes operate in parallel, with any issue of overlap dealt with through ordinary principles of double recovery. My own view, for what it's worth, is that the respondent's purposive interpretation is a stronger one. And I say that not simply because my head of chambers led the respondent's argument on behalf of Mr. Rice, but I actually think it's difficult to see why Parliament would have intended co-workers to be personally liable for lesser retaliatory acts, but not the most serious retaliatory act of all. But for the moment, and until judgment is handed down, claimant representatives would, I think, be well advised, where the facts justify it, to continue pleading both dismissal as a detriment under Section 47B and unfair dismissal under Section 103A. But that pleading does need to be done with thought. First, it's always important in the pleading to clearly identify the role played by individual actors. And secondly, pre-dismissal detriments must be pleaded carefully and separately. For example, a particular manager may orchestrate the claimant's dismissal by initiating proceedings, maybe engineering investigations, supplying misleading evidence, or otherwise acting because of a protected disclosure. And each of those acts may constitute a detriment in its own right, but they are not necessarily the dismissal itself. So even if Osipov is overturned, many of those detriments will survive entirely independently of the dismissal. From the respondent side, of course, the obvious point is to look very carefully at the way that the claim has been formulated, and in particular to challenge in response attempts to recharacterize conduct as dismissal when it's not. So just looking very briefly at the future, and firstly interim relief. Now it's obviously not a new remedy, but it's one that's historically been used only rarely. As we know, a successful application can be of enormous value because the claimant continues to receive full pay and benefits, including pension rights, until the final hearing, and the stinger is that there is no obligation to repay those sums if the claim ultimately fails. It also places very considerable pressure on a respondent. As we know, applications for interim relief must be made quickly before the end of the 7th day following the effective date of termination. And that places real pressure on the employer because they've got to consider the case, assemble some evidence at speed, knowing any weaknesses or inaccuracies may cause difficulty not just at the interim relief hearing, but also later at trial. And of course, the hearing is usually in public, which brings obvious reputational risks at a very early stage. To succeed, the claimant needs to persuade the tribunal that they are likely to establish at trial that they made a protected disclosure and that the protected disclosure was the reason or the principal reason for dismissal. And likely in this context requires a significantly higher degree of likelihood than more likely than not. To put it colloquially, the authorities have said, although I'm not sure how helpful this really is, that the claimant needs to show a pretty good chance of success or that their case looks like a winner. And I think we've all had clients who feel their case looks like a winner when we may disagree. In any event, although interim relief applications were once almost vanishingly rare, that does appear to be changing. I think I've been instructed on more interim relief applications in the last 12 months than over my entire career, and I'm very old. One obvious reason is the ever-growing tribunal backlog, which increases the practical importance of early financial protection. And I think as the backlog grows, we're going to see this renewed vigour in interim relief applications, but also because as from the 6th of April of this year, sexual harassment has expressly been added to the list of types of wrongdoing that can be the subject of a protected disclosure. And I think that leaves us with a very straightforward point for claimant lawyers. Where the facts involve someone speaking out about sexual harassment and then being dismissed, interim relief application should be considered early and seriously. I think that reputational point being a particularly key one tactically. And I think there's an equally straightforward takeaway point for respondents. Investigations, disciplinary records and decision-making trails may need to withstand scrutiny very quickly, so make sure that they are as full as they can be. The second future trend, I think, is a sexual harassment amendment itself. Now, in one sense, of course, that's a modest change because you could previously shoehorn it into one of the other categories, or at least attempt to, and of course the claimant still has to establish reasonable belief, public interest, a protected route of disclosure, however, etc. But now that sexual harassment is a standalone Section 43B category, claims that might previously only have been brought as discrimination or victimization claims may now be pleaded in parallel as whistleblowing detriment or whistleblowing dismissal claims. And as I said, one impact of that may be more interim relief claims. And just finally, for the future is a possibility of reform of whistleblowing law. In July of last year, the Department for Business and Trade published Grant Thornton's report into a review that had been instigated in 2022 under the Sunak Conservative government, if you remember that one. Several themes stand out. Firstly, that there's a concern about definitions, the issue being that concepts such as reasonable belief, worker, public interest are considered by many to be too vague, inconsistent and narrow. Secondly, there is a concern about redress, with the tribunal process being seen as too slow, too draining and too difficult to access. And there's also a concern about what protection it really gives in practice, with many participants reporting victimization after speaking up, and also many recipients saying the focus becomes about an employment dispute and not about the underlying matters about which the whistle was blown. Although the report doesn't promise wholesale reform, I think it does indicate pretty clearly that reform for whistleblowing remains very firmly on the policy agenda. And of course, the government now has a structured evidence base for saying that although the current framework is valued in principle, it's often failing in practice. So for now, in the short term, we await the Supreme Court's decision in Wicked Vision, which may redraw the line between detriment and dismissal. We also have the statutory expansion of the Section 43B list of wrongdoings to include sexual harassment. And behind all of that sits the government-commissioned review identifying dissatisfaction with the framework's definitions, protections, and route to redress. All of which means, I think, that we can safely say that whistleblowing remains a developing area of law. So watch this space. Thank you very much.